think that it is important that the hearing officer listen to this, not just read the transcript. I'm going to submit it into evidence. I would hope that you would listen to it.
And I will. I listen to way too much loud music as a teenager. As a result, as my wife and children would tell you, I don't hear as well as I should.
And I think it's important for, there is a lot of discussion about, and then there's also testimony, or not testimony, but comments from the public about the need for hours on Saturday. And I know that Mr. Cognity's indicated, that we're not here about to debate the policy issue, although his argument, he spent considerable time talking about praising the Secretary of State for his efforts to achieve uniformity and things like that. Okay, but in terms of what is probably most pertinent here, okay, some of which you already heard, which was the director, when at the beginning is asked what was the motion that was made, and she indicates from the transcript that it was the clarified motion to follow the directive, but then to also stick to the additional Saturday and Sunday hours. So that is directly contrary to, I think, the Secretary of State's position in terms of what the motion was that resulted in a tie vote.
And I just want to make sure we state for the record. I appreciate you had your volume up all the way. You've gone above and beyond to make sure that we have this available today. I would gladly accept that as evidence for consideration, and we'll listen to it as well as read the transcript. But in the interest of time, I just can't hear it well enough for us to have any of that.
One that I just mentioned, the Republican director actually states what the motion was, which was to follow the directive. Right. The second major point would be a discussion by Mr. Lieberman as to his interpretation of the directive in terms of not necessarily excluding a board of elections from having Saturday voting, that the directive is limited to the issue of basically prescribing regular business hours, and that this was going to be going beyond, by having Saturday or Sunday voting, it's going to be, the board is essentially going beyond regular business hours and be having in-person voting only for, or that would be the only activity that the board would be authorizing. And that position about the interpretation of the directive is also backed up on the disc, the recording by the legal advisor from the assistant county prosecutor, who's the legal advisor for the Board of Elections, where he also gives his view, his legal opinion. He makes it clear it's his legal opinion, not his personal view, that the directive is open to interpretation and is open to the interpretation that the Democratic board members had at the time in the morning when they made the motion and had the tie vote. Then probably the third thing to pay close attention to is the fact that while the letter from Mr. Damschroeder, was addressed to the board, that the board was to reconvene and the board was to rescind. You will see by listening to this that while it is true that Mr. Lieberman indicated that he would not rescind his vote or his motion, two things. The Republican members took no action. The letter was addressed to the board, to all 4 board members, to reconvene and to rescind. The Republican board members didn't make any effort to actually rescind. They didn't make a motion to rescind. They didn't make a motion to reconsider. They didn't do anything. In fact, Mr. Lieberman, after stating that he would not rescind his vote, he paused, he then made a motion to adjourn. that motion to adjourn was seconded by the Republican member. It didn't have to be. Republican members could have acted because the direction was to the board to rescind. And we saw no action by them, by the two Republican members, and yet we have only the two Democratic members who are being called before this tribunal. So those are the things that I would like you to focus on in particular. Okay. So with that, I would like to call as a witness Mr. Lieberman. If the reporter would please swear it in.
Sir, raise your right hand. Do you solemnly swear the testimony you're about to give in this court shall be the truth, the whole truth?
Thank you.
Okay, just state your name for the record.
Dennis Lieberman, D-E-N-N-I-S, L-I-E-B-E-R-M-A-N.
Okay, Mr. Lieberman, I want to ask you about the motion that you made on the 17th, morning of the 17th of the board meeting. In your words, what was the motion?
It was a motion to adopt the directive for our regular business hours, but also to include what we had previously voted on December 28th, 2011, which would be weekend hours, which I did not interpret to be regular business hours. Regular business hours are Monday through Friday, and weekend are exceptional. And so my interpretation was that we would adopt the directive as it was stated, and that we would then include what we had already done, which I didn't think was inconsistent, on December 28th of 2011. And so that was my motion. Now, I will say, earlier in some of the heated discussion, I misspoke, and that one word was read by counsel early on, but I corrected that later when I actually made the motion. And our counsel also wanted to make sure that that's what I meant. And he said what you had stated earlier, that my motion was to adopt the directive, to accept the directive for regular business hours, but to include weekends as the exceptional business hours, because we had already voted for that on December 28th of 2011, and I didn't believe it was inconsistent. And under, I think it's Title 3501.10, open paren B, close paren, I felt we had the legal authority to set hours of operation for the board, and this wasn't inconsistent with the directive.
And then after this resulted in a tie vote at that meeting, correct?
It did, yes.
And was the Secretary of State's office immediately notified of the tie vote?
That's my understanding. I went back to my office after the vote, and I received communications from our acting deputy director, perhaps, a staff member at the board, who told me that a letter had been received from the Secretary of State's office saying that we had to reconvene to rescind the motion, and the word rescind was used. I expressed to her my concern that we'd be in violation of the Sunshine Law if we convened that afternoon because of the requirements, and I expressed some surprise that the Secretary of State's office would compel us to violate the Sunshine Law. But that said, I agreed that if the rest of the board members wanted to meet at 2 o'clock, we could do that and discuss the matter and think about whether we should do what we're being told to do, not by the Secretary of State, but by Mr. Damshore. And so we met again at 2 o'clock that afternoon. And That's the tape that you were playing. At 2 o'clock that afternoon, we reviewed what had been done earlier. One of the Republican board members asked our counsel whether he believed that the directive was ambiguous, and our counsel gave his legal opinion that yes, he believed it was ambiguous, and that it left room for the interpretation that I had made in my motion to accept the directive, and to also simply reaffirm an act which we had already taken on December 28th of 2011. Frankly, I questioned at that time whether I needed to even reaffirm that, because it was an act of the board which the Secretary of State knew about, and the Secretary of State knew that Montgomery County wasn't the only county that had enacted weekend voting. In fact, several others have. Greene County, Warren County, Butler County, to my knowledge, had done that also. And so why it wasn't addressed in the directive, I have no idea. You have to ask them why it wasn't, why that wasn't mentioned in the directive. But because it wasn't mentioned, and because we had already voted on it, and because the Republican members of our board had agreed with us that weekend voting is critical for Montgomery County, we passed that in December of last year. We like to prepare ahead of time for our elections in Montgomery County. And so we passed that knowing that we were preparing ahead of time. We advised the public that that's what was going to happen. We did it through official notices. We did it through the postings. We did it on our webpage. And just several weeks ago, we had about 25, 30 members of the public who were representing different advocacy groups and churches come in and ask for clarification to make sure that weekends were going to be included. And the Republican members of our board and the Democratic members of our board unanimously stated to them, yes, it will be included. Therefore, based upon the precedent that we already have, and we had already voted on, and had not been told to us by the Secretary of State that we could not have weekend voting, I made the motion to keep it, as well as follow the directive, to do both.
Now, can I stop you there for a second? That was the motion in the morning.
Yes.
That resulted in the tie vote.
Correct.
Did the director notify the Secretary of State's office immediately that there was a tie vote?
That's my understanding, yes.
Because you received a letter from Mr. Damschroeder, shortly after the meeting, sometime in early, I guess, I think we indicated it was between 11:30 and noon.
Yes.
It was indicated there that there was a letter from the Secretary of State's office to the board about the tie vote and asking that it be, and Mr. Damschroeder ordering that it be rescinded by the board.
Yes.
Okay.
Now, and if I can only add to that, we had already agreed, as is the practice in my tenure as sitting on the board, that we would be given a briefing schedule as to the tie vote, and that briefing schedule was supposed to be August 22nd, which would be Wednesday, when after the transcript was prepared of our hearing, both Democrat and Republican members would be given a copy of the transcript. We would then, from that transcript, write a brief to the Secretary of State and give our reasons for the vote the way that we did. And this has been a common practice ever since I've been on the board. And that the Secretary of State, it's part of due process, that the Secretary of State would then listen to both sides and then break to the top. So I was back in my office doing the research and getting together the statistics to try to support our position that weekend voting should be supplemented with following the directive provided to us by the Secretary of State. and that's when I got the call.
And just so we're clear here, after the tie vote, the board decided to set August 22nd as a date that both sides would submit their arguments to the Secretary of State.
Yes, now, usually we give longer periods of time, but in recognition of the fact that indeed this came at us 80 days before the election, not 9 months ago when we had actually adopted our Saturdays, but 80 days, we decided that the best thing for us to do was to expedite this process, which we believe is the due process right that Secretary of States have followed ever since I've been on the board, and I think Tom would probably agree with that. He's been on it for 17 years. So,
And are you aware of the Secretary of State's directive on procedure for submitting tie votes?
yes, we're supposed to brief, provide the transcript and brief.
You're aware that directive allows up to 14 days to submit arguments?
Yes, yes.
But you decided, the board, all four board members decided to submit it within 5 days.
Right, so we'd already taken action on the motion itself, and which then leads to the afternoon